Well, the evidence is the first-hand accounts of my constituents who are telling me this happened. That's the evidence. Is it normal that people just get 33 bomb threats when Trump makes a comment about immigration? No. Trump's made many comments about immigration. It's not 33 bomb threats that happen every time. Maybe it's just the Haitians. Wait a minute. You're charging Trump and Vance with making false and inflammatory comments about the Haitians, and then you're showing up and making false and inflammatory comments about the prosecutors. Trump's criminal charges not moving forward after they were brought by the Haitian migrants. Trump, of course, had the infamous comment at the debate, "Eat the cats, eat the cats." And everybody melted down over that, including the Haitians and the people over at Haitian Bridge Alliance and Gwendolyn Joseph. They came together with a law firm in Ohio called Chandra Law, and they crafted a set of criminal charges. Now, Ohio allows you to bring criminal charges, and so they brought them against Trump. And in fact, they wanted Trump and Vance both arrested and charged with these criminal offenses: disrupting public services, making false alarms, inducing panic, complicity, telecommunications harassment, aggravated menacing, inducing panic, and more harassment, and on. Now, they wanted actual warrants issued. They wanted Trump and Vance arrested. And we read through a sizable portion of the original, we'll call this a criminal complaint. But as you can see, the Ohio law authorizes a private citizen to charge criminal offenses by filing an affidavit. And we read through the memo and portions of the affidavit. And so they amended this. This has been changed. They submitted it to the courts in Ohio, and the courts have responded. And boy, is it good. You can see the judges respond to Trump's Haitian migrant criminal charges. Municipal court out of Clark County, Ohio. All right, guess what? Gwendolyn Joseph and the Haitian migrants have now brought charges under Ohio code against Trump and JD Vance. They filed the affidavit. We read through it. They want them prosecuted, and they want them arrested. Arrest warrants and summons issued. Now, they filed an amended affidavit that also included 30 pages of factual statements that alleged criminal behavior by Trump and JD Vance. The crimes are as follows. We read through them: misdemeanors, 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 misdemeanors. And so the court came out and said, all right, listen, we've reviewed everything. We reviewed your affidavit, the amended affidavit, the bench memo that we read, the flash drive of the video clips, Trump's comments about eat the cats, eat the cats, and everything. And we've also read the statute that you say gives you power to charge. Now, here's what the law says: that we shall issue an arrest warrant if the things happen. And so let's break it down. The offenses here that are alleged against Trump, when it's a misdemeanor, the court may issue a warrant if it chooses. Now, at first blush, it would seem that that paragraph leaves no room for the court to exercise its independent judgment. But guess what? That is misplaced. We can make this interpretation and decide whether to issue a warrant based on this obscure Ohio law that allows civilians to file criminal charges. First, the paragraph about the charges of a felony is shall. It's mandatory. Thus, the court is required to either issue a warrant or refer the matter if it's a felony. But if it's a misdemeanor, then it shifts over to may. So it goes from must to may. If it's a felony, you must then refer it over. And this one here is a felony. So we've got 1 4th-degree felony. The rest are misdemeanors, absent this one. Inducing panic could be charged as a felony, but the others look like they'll be charged as misdemeanors. So they're making a distinction there. Obviously, felony is much more serious. Thus, the court has the discretion for the misdemeanor charges. Now, it's also true, obviously related to criminal law, we can't issue warrants without probable cause. So just because you bring a felony charge doesn't mean we automatically pursue it. So it's may for the misdemeanors and probable cause for all of them. So even with a finding of probable cause, we still, if it's a misdemeanor, could decline to issue an arrest warrant if we so choose. Now, the court turns to the question next, once we know how the rules work, of whether the claim is meritorious at all. Will you succeed? Is there probable cause to support the allegation that a crime or crimes have occurred in this case, because Trump said eat the cats? Probable cause exists where facts and circumstances are sufficient to warrant a prudent person to believe that the suspect has committed a criminal offense. Now, all of the conduct alleged in the affidavit centers around statements, words that were made either by Trump or JD Vance. And guess what? Freedom of speech is among our most precious and protected constitutional rights, unless you're a Democrat. It's enshrined in the First Amendment of the United States that they want to get rid of actively. And indeed, the United States and Ohio Supreme Courts have recognized this. The importance of speech even when it stirs people to anger, quoting case law. Now, in this case, not only do the allegations, these criminal charges from the Haitians, not only do they raise the issue of speech, but they complain of political speech. And we know that political speech is at the core of what the First Amendment is designed to protect. In a widely cited case, the United States Supreme Court reinforced the vital interest in our democracy, protecting speech that's critical of the government and protecting political speech. They said, there is no question that speech critical of the exercise of the state's power lies at the very center of the First Amendment. Speech is an essential mechanism of democracy, for it is the means to hold officials accountable to the public. It's our only means, and we get to vote in botched elections. Therefore, political speech must prevail against laws that would suppress it, whether by design or inadvertence. Laws that burden political speech are subject to strict scrutiny, the highest standard, which requires the government to prove the restriction furthers a compelling interest and is narrowly tailored to achieve that interest. So we protect speech highly, aggressively. Speech remains protected even when it may stir people to action, even when it may move them to tears, or even when it may inflict great pain. Apply that all to Trump and January 6th stuff. The constitutional guarantees of free speech and free press do not permit a state to forbid or to prescribe advocacy. Now, although all speech does not have absolute constitutional protection, the strict scrutiny analysis of any criminalization of speech requires thorough and extensive investigation before we'll allow you to charge somebody. Now, here, the First Amendment protection of the speech factor into our analysis and into the good faith nature of all of these allegations that are even brought by the Haitians. Now, this election is less than 35 days away. Wow. The issue of immigration is contentious, and due to the proximity of the election and the contentiousness concerning the immigration policies of both candidates, the court cannot automatically presume the good faith nature of the affidavits that were brought by the Haitians. That is not to say that the affiant, the affidavit, does not believe that what she is alleging is true. She might think that she's true, but rather whether the conclusions that the affiant reaches, which is that being that Trump and J.D. Vance's political speech are crimes, it could be influenced by her personal experiences, right? As opposed to an objective analysis of the alleged speech and the constitutional protections that are afforded to that speech. This is why we have prosecutors that are supposed to do independent reviews and pursue crimes, criminal charges in the interest of justice, not because you're some upset Haitian or complainer, right? Part of this organization. The alleged conduct occurring within the community and the claimed nexus between the speech and that conduct. Now, a nexus or causation between the speech and the acts committed by the other people, as alleged, cannot be presumed. In this case, the conduct referred to is a speech, and for probable cause to exist, it is not sufficient that Trump or Vance might have foreseen the acts that they alleged in the affidavit. Like they could have predicted that maybe something bad could happen if they said the thing. That's not how that works. It's did their statement actually cause those bad things that you're alleging to happen? And is that criminal under the codes that you've alleged? So they say for probable cause to support a prosecution here, the totality of the circumstances must prove that the statements by Trump and Vance are not entitled to First Amendment protection. And the statements are completely false. The statements are the direct and proximate cause of the alleged behavior of others. The alleged behaviors of others was criminal, and that the criminal behavior should have been reasonably anticipated by Trump and Vance as imminent, resulting from their speech. Whoa, that's a mouthful, right? That's basically the new standard. Every one of those sub-components could be its own checkbox. And so you could just think that out. Now, the concurring opinion elucidates the factual considerations, which may bear probable cause and good faith in this case, but however, the majority of this panel did not believe that it's this court's place to further address probable cause or good faith based on the disposition of this case. Here's why. The judiciary and the prosecution have separate functions, okay? Courts are not investigative bodies. It's appropriate for the court to act on reliance upon a prosecutor. This is particularly true where the allegations are of a serious nature, and for the reasons set forth in the concurring opinion, with which the full panel agrees, we agree with everything that guy said, the conclusion of whether the evidence and causation is necessary for probable cause exists to commence a prosecution of the alleged offenses is best left to the prosecution, right? If they want to talk probable cause and all that, that's for them to determine in order to initiate this. The prosecutor's determination on probable cause will render the good faith basis for the affidavits moot. If they decide it's good, then we don't need to address that here. Now, the statutory scheme under which these criminal charges are filed does not permit this court to simply deny the request and dismiss the allegations as it relates to the felony charges. And so rather, because the court questions the existence of probable cause, cause and the good faith nature of the affidavits, because it's very close to an election, it's about immigration, the court is required to refer the felony charges to the appropriate prosecutor. And so therefore, the court cannot dismiss the affidavits and its requests in their entirety, because the law says you got to send it over. But it's the opinion of this panel that the discretion afforded concerning the misdemeanor charges would permit the court to dismiss those. However, since the misdemeanor charges may be filed in conjunction with felony charges arising out of the same facts or circumstances, it is appropriate to refer all charges to the felony prosecutor for further investigation as to whether there is probable charges for the charges, with particular consideration, okay, the court says, to be given to the strong constitutional protections afforded to speech and political speech in particular. So this is the court basically notifying the prosecutor that there's nothing here. So just be advised. Now, it's therefore ordered that all matters set forth in this affidavit filing in this court are hereby referred to the Clark County prosecutor, and they're going to decide whether any further prosecution is warranted. And the likelihood of that is probably low, especially given this final admonishment from the court that it's not warranted here. So we'll read a statement from the law firm and see if the prosecutor will pick this up, the law firm that just lost this. But here is the concurring opinion, which is brutal. It says, this court has reviewed all the documents, and I concur in full with the finding and the opinion of the court. Now, this opinion is to document further reasoning as to the decision of this judge. Now, the court concludes there is no necessity for a hearing in this matter. Counsel for the criminal charges person stated in a bench memo, they said investigation is neither needed nor requested. The Haitians have submitted extensive materials, bench memos, amended bench memos, supplemental bench memos, and more. Now, the statute, the law, does not require a hearing, and the court has no obligation to set the case for a hearing. Case law does require the court to make two inquiries, though. The first is whether probable cause exists as to all elements of the crimes, or the claim is not meritorious, and the second is unless the judge, clerk, or magistrate has reason to believe that it was not filed in good faith. Probable cause and good faith. Now, the court notes that the affidavit from the Haitians and the request in this case was not filed by a layperson. It was filed by lawyers. The filing is signed by one lawyer, but it lists 4 different lawyers as representing the parties requesting the action. Now, the first issue that will be addressed is the issue of probable cause. They say the materials submitted make no specific allegations to venue in Clark County, Ohio, and that's critical. Their filing is not a criminal complaint. However, it does request that a complaint be filed on the basis of the allegations. So what is the geographic nexus specifically? The affidavit of Miss Joseph indicates that we have spoken to immigrants in Springfield, Ohio. Okay, so those are the victims, maybe? Paragraphs 9 through 13 allege different incidents or different fears of Haitian individuals in Springfield. And while the court should not have to guess at the specific allegations of venue, where did the crime actually happen? These averments could establish venue in Clark County, Ohio, under some provisions, and these are hearsay. Now, the finding of probable cause may be based upon hearsay in whole or part, provided there is a substantial basis for believing the source of the hearsay to be credible and for believing there is a factual basis. Now, the statements in paragraphs 9 through 13 allegedly were made to unnamed individuals working with the Haitian Bridge Alliance. So who are these people? The individuals who allegedly made the statements to the unnamed individuals from the Haitian Alliance are also not identified. So the people who made the statements to the Haitian Alliance don't know who they are, and the people who got the statements at Haitian Alliance, we don't know who they are. So the court is asked to find 2 layers of hearsay submitted by unnamed individuals that they have a substantial basis for believing the source. That's the source, okay? Well, this hearsay not only goes to the establishment of venue, but also to elements of some or all of the crimes that you want us to make independent findings on. Now, there is no information submitted to the court that can be examined for the court to find that the unnamed sources of these statements are credible. How can we even know if they're credible? To believe what they said. So without a basis, we can't make the required findings. We don't even know if it's true or if they're credible. Now, similarly, look at this judge, man. Paragraph 7, 8, 16, 17, 18, 50, 51, 57, 61, 69, 76, 79, 96, 97, 98, 100, 101, 107. So he's sitting there with a red pen, just like we are right here, marking every paragraph. Oh, there's one. Reading, reading, reading. Oh, there's one. Reading, reading, reading. Oh, there's one. Marking them all down. Saying, all right, they all allege that Trump and Vance knowingly made false statements, specifically concerning dogs, cats, and geese. The affiance materials rely heavily on statements by Governor DeWine and local officials to attempt to establish probable cause of the false nature of the statements. But the statements from the officials repeatedly indicate the following very similar statements. They all say something like this. We wish to clarify that we have not been able to verify any credible reports. They've found no credible evidence. They have no evidence of that at all. No verifiable evidence or reports show this was true. We just have no verifiable claim that this actually happened, and many similar statements. Now, the court acknowledges the difficulties of proving a negative. There is a significant difference, however, between stating that there are no verifiable reports that a statement is true and proof and or probable cause that a statement is false. This judge has tremendous respect for the officials making the statements, but if any of the officials voice the opinion that the statements at issue were false, those statements are in the form of opinion, and Ohio rules of evidence state that if the witness is not an expert, the witness's testimony is an opinion. So that's just their opinions. There is nothing in the reported statements by the officials that on the basis of the record before the court would justify any opinion that the statements at issue are false, just that they cannot be verified as true, right? They're different. We don't know if it's true, doesn't mean that they're false. There's no evidence that that is happening, doesn't mean that it's not. And you're allowed to say those things. You're allowed to make these statements, and then other people can refute those. You don't get to charge people with crimes for that unless you're a psycho. Now, the affiance materials implicitly acknowledge, the Haitians, that there were reports that led to the statements at issue. Reports came out, right, that actually led to the statements. Trump didn't just make it up out of nowhere. The court is left to speculate from most of the materials as to why the reports were not verifiable or credible. Did police respond to the reports? If there was a response, what was the elapsed time between the report and the arrival of the officers to investigate the report? What are the articulable facts that would justify the opinion that the reports are false? Because there were reports. The statements may be false. There appears to be no evidence outside of the acknowledged reports that the statements are true. The statements may be true, but there is no factual basis for the court to find that the statements are true or false based on those statements of the officials. And once again, the court should not be left to speculate about this. Probable cause is based on articulable facts, not on speculation. And in addition to citing statements by local officials, the Haitians also rely on interviews conducted on CNN with Vance as evidence that Trump and Vance were purposely making false statements. They wrote in their affidavit, they said, quote, "In the same interview, Vance admitted that he was just making harmful statements up." Vance said, "If I have to create stories so that the American media actually pays attention to the suffering of the American people, then that's what I'm going to do, Dana." Now, the referred to interview is contained in what is labeled paragraph 59 on the flash drive that you gave us. The interviewer also labels the statements as false on CNN, Dana. "That's false. That's not true. They're not eating cats." The court has reviewed the recording numerous times, this judge. The court sees nothing in the interview that is an admission by Vance that he was just making harmful statements up. When asked about the evidence as to the statements of Vance, Vance replied, "Well, the evidence is the first-hand accounts of my constituents who are telling me this happened. That's the evidence." When the interviewer questioned him about creating stories after the quote in paragraph 52, he said, "Dana, it comes from first-hand accounts of my constituents. I say we are creating a story, meaning we are creating the American media's focus on it. By creating a story, we're making this like a focal point." The interviewer even later says, "I have not accused you of anything," right? Dana says, "I'm not accusing you of making this up." But then they said he made it up just to hurt people. It's a fake quote. So the statement in paragraph 52 is inaccurate, right? The Haitians' criminal charges are inaccurate in paragraph 52. When the interviewer referred to the false claims on Face the Nation, Vance said, "Yeah, I've heard about a dozen things from my constituents in Springfield, Ohio. 10 of them are verifiable and confirmable. A couple of them we have district first-hand accounts, for example, of migrants abducting geese at the local park and slaughtering them and eating them. Maybe all these constituents are lying to me. I would appreciate it if the American media would show up and did some real investigation rather than amplify the worst people in the world. Why is someone calling in a bomb threat?" So that they could blame Trump, I guess, and you, JD. So they submitted that. The Haitians submitted that paragraph. Now, in response to a PBS show, another member of the media asked a similar question to Vance. Vance said the same thing. "I've got residents in Ohio coming to me with a dozen problems, talking about it for months. Overwhelming small towns." You got the quote from JD. Now, those accounts and those quotes were submitted by the Haitians, showing that JD was making false statements. But those don't sound false at all. Like the earlier statements discussed, the above quotes are hearsay from unidentified individuals in those other paragraphs, and they cannot be considered for the truth of the matter asserted. However, right, so these people are telling JD things, right? These people told JD things just like the Haitians told the Haitian Bridge Alliance things in their criminal complaint. So everybody's just talking about stuff and the harms and what's happening. Now, they also cannot be considered for the truth, but they could be admitted as part of Vance's state of mind. His mens rea. So did he know that he was saying false things, or did he think he was saying true things? Because that's what his constituents were telling him. It also could go to the state of mind of Trump as to when the statements were made. So there is nothing, says this judge, in the submitted materials indicating that officials and or media and or counsel for the Haitians are making any efforts to investigate the reports from the senator's constituents. Are you guys going in and checking into these geese abduction stories? Counsel actually said in their report, right, the lawyers said themselves, investigation is neither needed nor requested. We already have enough evidence that we need. And so those reports may be false, but they may also be credible and true. Vance seems to believe the accounts are true, and the above material submitted by the Haitians negates probable cause as to the required mens rea. Vance needed to have knowingly thought that they were false, or knew they were false, that they were not eating the cats, eating the dogs, and then said they were anyways, right? His mindset was, no, I'm hearing from my constituents. It sounds like the geese are gone. So the court is once again called on to speculate here and assume that the reports are false, but they're not going to do that. Probable cause is not established by speculation. Mens rea, the mindset, is determined by evidence, including facts and circumstances. Now, the crimes that the Haitians are contending, that they want Trump and Vance to be arrested, they disregard mens rea and the mental state. The court considers the Haitians' paragraph 52 and 7 to be inaccurate and misleading. Busted, man. Misleading. The evidence submitted in the above paragraphs on the flash drive is, if anything, it's exculpatory. It exonerates them. It tends to exonerate former President Trump and Senator Vance of the guilty mind. Once again, the court is left to speculate as to the exculpatory strength of these accounts, but the evidence that's submitted by the Haitians tends to show that Trump and Vance relied on reports that were made to them by constituents. So they weren't making up anything. Your evidence shows that. They said it in your own evidence that they got it from constituents. So you have to establish probable cause, that they knew that that was false. The above listed evidence negates probable cause because it negates the mens rea. It's usually must be established by facts and circumstances. And what you've submitted does not do it. The submitted materials do not establish probable cause that the statements are false at all. The materials also do not establish the statements are true. But we got speculation here, and that's what free speech is all about. So the Haitians claim that Trump's statements about the Haitians have caused multiple bomb and other threats and closures. Trump's statements caused the bomb threats. That's why they happened, because of him. Now, causation is also an element of a number of the charges, and the jury instructions define what is cause. What does it mean? Well, it's an essential element of the offense, is an act or failure to act that in a natural and continuous sequence directly produces the harm, and without which it would not have occurred. The defendant's responsibility is not limited, these are the instructions, to the most immediate or most obvious result, and the defendant is also responsible for the natural and foreseeable consequences in what has flowed from the event. Now, did Trump cause all of these bomb threats? You said that there were 33 bomb threats in the days following the debate. Now, the materials contain very little information as to the exact threats, other than to label all of them as hoaxes, so we don't know anything about them. Now, the Haitians also seem to contend that due to the threats being in close proximity to the statements, that probable cause as to causation is established. So Trump said the thing, and then bad stuff happened, so therefore Trump is responsible. But the materials do contain some insights into the threats. Governor DeWine does have information concerning the investigation into the threats that he's made public. The governor gave us the following information that they submitted to us in their flash drive. He said 33 bomb threats, Governor, each of which was responded to and found to be a hoax. 33 threats, 33 hoaxes. We have people, unfortunately, overseas who are taking these actions. Some of them are coming from one particular country. We think this is one more opportunity to mess with the United States, and they're continuing to do it, so we cannot let the bad guys win. Our schools must remain open. Now, the governor later declined to identify what country the threats were coming from. I don't know. He should have told us that. Now, the governor later gave some additional information in an interview. He said some of the bomb threats came from foreign nations. Others came from the United States. All of them have been hoaxes. None of them have panned out. Now, look, the people who are making these threats are the bad people. They are the wrong people. Some come from overseas, want to mess with the United States. We have some coming from the United States, from people who are sick, who think for some reason this is funny. Now, the interviewer then interrupted the governor and asked him if the statement stopped, would the threat stop? The government replied that he could not predict what would happen. So the first question then is whether in the natural and continuous sequence would the threats have been made without the statements? So would these things have happened if Trump had not said anything, or Vance didn't say anything? The second inquiry is whether the threats are the natural and foreseeable result that would follow in the ordinary course course of events. So if Trump says something like that, is it normal that people just get 33 bomb threats when Trump makes a comment about immigration? No. Trump's made many comments about immigration. There's not 33 bomb threats that happen every time. Maybe it's just the Haitians. There are limits under the law to what the court can refer to as a causal chain. The question is how far the chain extends when the potentially inflammatory remarks are made and bad things follow. Now, the only evidence before the court is that the threats were made from some foreign countries and or overseas who want to mess with the United States and from other people, quote, who are sick, according to the governor. Sick people are sick. There is nothing in the record to indicate that the bomb threats were made by any local individuals. Is there probable cause to believe these threats were the natural and foreseeable consequence by what Trump and Vance said? Now, the court notes that the governor indicated that he could not predict what would happen if the statement stopped. The inquiry has some far-reaching implications in political discourse in the United States and our implementation of criminal statutes. You want to play this game, lefty boys? The inquiry could be made in a large number of situations. For example, there were calls to hold President Biden responsible for his comment about time to put Trump in a bullseye. Remember that? When the attempted assassination occurred. Did Biden cause Trump's assassination? Should he be indicted for that? There were calls to hold Senator Sanders responsible for comments that he made, and one of his volunteer campaign staffers shot Congressman Scalise and other individuals at the softball practice. This court strongly believes that President Biden and Senator Sanders did not cause those events. The court also believes that the time proximity alone cannot establish causation. There is nothing that the natural and foreseeable result would follow that any of this would happen here. When the threats that were made were from foreign countries who were trying to mess with the United States and other local people who were sick. If someone was wanting to mess with the United States, there's nothing in the record to indicate that the threats would not have been made without Trump's statement. And it also doesn't appear to be a natural and continuous sequence. So therefore, there is no causation. And the court finds that there is no probable cause established as to the causation of the bomb threats and anything coming from the statements. And so therefore, these materials submitted on a flash drive contain a significant amount of information centered around the Temporary Protective Status Program. It's the understanding of the court that TPS status is a temporary status that allows foreign nationals to live in the U.S. for a limited time. According to ICE and DHS, they've extended this for people from Haiti. It's also the court's understanding that Homeland, in consultation with the State Department, designates the TPS time periods. The designation can be extended or terminated by the President of the United States. Now, the Haitians claim that Trump cannot order the deportation of legally admitted immigrants. Now, the problem with that position is that their status is temporary. DHS at this point has extended TPS status for the Haitians until August 3rd, 2025. Now, the evidence indicates that comments by Trump are an indication of what he intends to do once he wins the presidency. In my words, not the judges. It appears that the president could order the individuals from Haiti who are here under temporary status to leave the United States or be deported after August 3rd. And so it appears that if elected, he would have the authority to redesignate that or to terminate the program. And if he decided to do any of the above, he would be acting in his official capacity as the president. And guess what? The Supreme Court just came out and affirmed the president has absolute immunity for any official acts that involve the core duties of the president. And so statements concerning deportation appear to be statements of intent as to how former President Trump intends to exercise his discretion on immigration if he's elected to another term, which means he needs to be free to talk about those things. That's the First Amendment. Great stuff. Now, the crime of aggravated menacing that they want him charged with also requires that the offender will cause serious physical harm. Once again, these Haitians do not specify an individual victim at all. Deportation could be quite distressful to an individual who wants to stay into the United States, but it's not serious physical harm. Like, deportation might suck for that person, but it's not serious physical harm. So there's no probable cause for aggravating menacing. And the court also finds that based on the information provided in the amended bench memo and the affidavit, that probable cause does not exist. It's not meritorious as to the charges, so the court will now turn its attention about whether this action was filed in good faith. The court has a number of concerns about the filing of this action. First of all, this action is filed within 60 days of the presidential election. The question always arises in such cases as to whether filings are filed in a manner to affect an election without giving the accused sufficient opportunity to even defend the action before the election occurs. Nailed it. There was a significant amount of material submitted to review in this case. It took many hours to adequately review and to consider the points made. The bench memo asked this court to forthwith issue warrants for Trump and Vance's arrests. It was like nuts. It goes on to state this court should be done before Trump fulfills his threat to visit Springfield Springfield, so that he may be arrested upon arrival for his criminal acts. Now, it should be the goal of lawyers that this action is evaluated thoroughly and that a fair resolution be obtained. It should not be to influence a presidential or vice presidential candidate who they choose to, where they choose to campaign. It should not be a stage to stage an event where candidates can be arrested if they arrive in our state. Now, the language used to advocate for the action brought by these lawyers is troubling to the court. It is noted that she interprets Trump's announcement that he will visit Springfield as a threat. Now, the court does not interpret the announcement, which I saw in the materials, as a threat, okay? The bench memo and the affidavit constantly refer to the statements in issue as lies. And as noted in the court's decision, the evidence produced does not even establish probable cause that the statements are false, much less lies. So the court is concerned about these lawyers' statements about the prosecuting attorneys that also work here in this community. Court's defending the prosecutors. There is nothing in the filing that indicates that these Haitian lawyers has even spoken to a local prosecutor about his concerns, and apparently they don't even have any knowledge, even is an investigation. And so this case revolves around what have been characterized as false and inflammatory comments by Trump and Vance. The comments about the prosecuting lawyers have nothing to do with the issues that were submitted to the court for our determination. The court finds it interesting that the lawyers would make what the court would consider to be false and inflammatory comments about the prosecuting attorneys who serve Clark County, Ohio. Wow. So this is a blowout, man. So wait a minute. You're charging Trump and Vance with making false and inflammatory comments about the Haitians, and then you're showing up and making false and inflammatory comments about the prosecutors. That's interesting. The court finds it interesting. Yeah. Now, the above statements by the lawyers and the Haitians could, however, make for interesting quotes in the media. That's exactly right. The court, as noted in this decision, is particularly concerned about counsel and the affiant statements that Senator Vance admitted to, quote, just making harmful statements up. The court considers this to be a significant mischaracterization of the evidence submitted to the court. Significant mischaracterization of the evidence. Now, the action is filed by 4 lawyers, says the judge. The court has pointed out what the court believes to be glaring deficiencies in the requested charges. Counsel states further investigation is neither needed nor requested. Yeah, the court respectfully cannot disagree more. The court finds that this judge has reason to believe that this was not filed in good faith. This court also finds, pursuant to Ohio code, that the claim is not meritorious. Both findings are for the reasons set forth in the concurring opinion. Now, having made the original findings above, there is only one option here. The court sends this matter over to a prosecuting attorney for investigation. Wow. So, signed by the judge, Stephen Shoemaker, just nuking the Haitians' claims of criminal charges and really lambasting the attorneys. 4 lawyers brought this? This is what you guys brought to our desk, and now you're scolding the prosecutors? That was very, very enjoyable. So, great opinion out of Clark County, Ohio, the municipal court. Those charges will go over to a prosecutor, so they're not gone yet. But based on what we just saw here, unlikely that any prosecutor is going to want to pick those up and move forward with them because of the deficiencies in their process. Now, this is the law firm's website. They've responded. They said, in response to the opinions of the court, we released the following statement. They say the court's opinions are deeply flawed, and the Haitian Bridge Alliance is disappointed by the court's decision, saying there was an irregular process, saying they made up a special procedure, saying that there's a problem with how they determined causation. So circumstantial evidence example is what they're using. Snow outside, you wake up, there's snow on the ground, you can infer circumstantial evidence. Trump and Vance's falsehoods, mischaracterizing the release, denying a hearing. So let's see what they're going to do. They say because prosecutors haven't acted to protect our community, the bridge is skeptical about whether they will do so now, especially when the court is giving them cover not to act. So it's hard for the bridge to believe that there's equal justice under the law when Trump and Vance get special treatment. Okay. So they're trying to have their political opponents arrested for just saying some things that are based on reports from actual constituents who live here, who say that this is happening. They'd like to have the Haitians have so much equal protection that anybody who criticizes or even says anything about their community, whether it's true or not, and this is America, by the way, you can say things that are not true about certain things, not necessarily intentionally, but you can have questions about it, right? Is this true or not? Is this report something that has been confirmed or not? They were never out there openly, actively, maliciously making up claims as they would have you believe, and that's why those charges got dismissed.